You are getting married. Congratulations. Now that you are entering a new chapter of your life with a new person, there are some very important decisions you need to make about your legal planning for your whole life. Remember, legal planning is not just your will, although that should be updated. It's also your incapacity planning. Eventually, most of us, get sick. We need other people to help us. So your incapacity planning in the form of a power of attorney and an advanced healthcare directive really should be updated to reflect that you have a new spouse. I'm Patrick Cawley with Keystone Elder Law, and here are just a couple of the most common changes that come up when there's a marriage. Number one, your beneficiary designations on your life insurance, your pension plan, your 401k, your IRA. These are all places where you have money and you have already listed somebody to receive that money if you should pass away. If this is your first marriage, until now, maybe you listed a parent or maybe you listed a sibling to get a payout if you passed away. Now you have a spouse. So you want to update it so that that payout goes to your spouse if that's appropriate for you. If it's your second marriage, this is even more important because imagine how awkward it will be if you pass away and your husband or your wife is expecting that the life insurance or your 401k is going to leave money to them, but they find out that you never changed it and it's your first spouse. Your ex is listed as the beneficiary. Guess what? The ex is getting the money. That will be very awkward. So you want to update it to make sure that that X is no longer listed on those policies. So that's the beneficiary designations, just because it's a pot of money you have somewhere and that happens outside of your will. That's just a deal you have with a financial services company or a bank or an insurance company. And you want to make sure that they are updated on the deal that you are now remarried. So the next has to deal with your fundamental estate planning documents. The three fundamentals are a will, a power of attorney, and an advanced healthcare directive. So if you still have your ex listed as a beneficiary of your will, so they're going to receive what is titled in your name at the time of your death, that actually will just not be honored. So it will go to whoever else is listed in your estate. So that's right in the law that your ex-spouse, that part will be invalidated and it won't go to them. So it's not as much of a concern as the beneficiary designations, but you really ought to update your will to include your new spouse. If time has passed, you might have different needs and goals with your estate planning. You might be planning for the possibility of long-term care in your later years. So it gets a little more complicated anyway. And you probably want to build some trusts into your will as an asset protection measure. That's something that we can talk about. But you also want to update your incapacity planning because your new spouse probably wants to be in a position to make medical decisions for you if you can't talk to your doctor. That person is going to know probably better than anybody in the whole world what your wishes are for care if you may be near the end of your life. These are big, weighty decisions, and you want your new spouse to be formally authorized under the law to make those decisions for you if you become incapacitated. Same goes for financial decisions. Maybe it's finances that the two of you have worked on together. You want your spouse probably to be the one who stands in your shoes legally to talk to banks and insurance companies, to sign agreements for your care. So you want to update your power of attorney to make sure that your spouse is in a position to do that. Here's the tricky issue. If you have kids, either your new spouse or you from a previous relationship, how do you make sure that your new spouse will take care of your kids if you pass away? Maybe you don't have a concern about that. A lot of people in my experience do not. But if you think it through, what happens if you pass away and your new spouse remarries? Will there still be a motivation there to take care of your children? I find a lot of people aren't really concerned about that. And then I ask the next question, what if you die, your spouse remarries, and then your spouse dies having remarried to another person? Now there's this stranger out there who's never met you, never met your kids. What is that person's motivation to take care of your children, your biological children. If that is a concern for you, there is trust planning where that can all be detailed out so that a certain amount of money upon your passing is passed away, is set aside and is protected for your children. So these are just some of the issues that come up when there's a marriage. If this speaks to you at all, if you have questions, ask in the comments or reach out at info@keystoneelderlaw.com and we'll get answers to your questions.